This is going to be a fairly high-level overview of what the issues are in this area, because really at the end of the day, it is, as the title says, I'll know it when I see it. And for those of you who are not familiar with that quote, it was a US Supreme Court Justice back in 1964 when he was asked, how do you define obscenity? It was in the context of pornography and whether something was pornography. And his answer to that was, I'll know it when I see it. As you can imagine, that doesn't offer a lot of guidance in terms of how you would tell if something is or is not what the term means. So from this perspective, what I'm going to talk about today is really take a quick look at the legislation for marriage-like relationships in the context of WESA. I should stress that. This is not related to family law or the Family Law Act. It is related from the context of the Wills, Estate, and Succession Act. I'm going to look at the legislation briefly. Then I'm going to look at some of the court consideration. There was a couple of cases last year, Court of Appeal cases last year, which touched on this and offered guidance, if I can put it that way. Really, I would summarize the guidance as it's contextual. You have to look at all the facts, it's idiosyncratic, and then make a decision. So we'll look at that and some of the indicators that have classically been considered as in things that reflect a common law or a marriage-like relationship. So the legislation. So the Wills, Estate, and Succession Act is Section 2, and it says when a person's spouse under this act, I don't know how I managed to screw up the title, but it should be under this act, and two persons are spouses of each other for the purposes of this act if they were both alive immediately before a relevant time, and we're looking at B, they had lived with each other in a marriage-like relationship for at least 2 years. Now, it doesn't have to be as of the date of death. At any point, they lived in a marriage-like relationship for 2 years. And then you sort of say, all right, well, what does that mean? What is a marriage-like relationship? And then you go on to say, or it goes on to say that it terminates a common law or marriage-like relationship that's not legally formalized, terminates when one or both persons terminate the relationship. And obviously that creates other issues in terms of how do you know if they were in a marriage-like relationship when it was terminated, if they continue to live together, for example. What are the indicators as to it has ended? And then we go to section 2.1. Spouses are not considered to have separated if within 1 year after separation, they continue to live or they begin to live together again, and the primary purpose is to reconcile, and they live together for at least 90 days for one or more periods. So, and again, you start dicing the onion pretty fine when you say, well, one or more periods to only 9 days. Well, if it was, they started getting back together and they spent 5 days together here, and then 2 weeks later, they spent another 5 days together and adding up to 90, does that count as getting back together? Again, we don't really have much guidance on the case law for this, for that particular thing. So it would be, as I said at the beginning, idiosyncratic. Now, what have the courts said about this? Well, the one thing that has come through very loud and clear is that the analysis, the legal analysis of whether something is a marriage-like relationship requires a contextual and holistic approach. And what I mean by that is you can't look at any one factor, nor should you view it as a checklist. And I'll go through the factors in a second, but judges have been criticized by the Court of Appeal for going through the checklist like it was, well, they do this, they do this, they do this, then they must be marriage-like. No, the Court of Appeal has said that's not how you approach it. You look at the factors for sure, because that helps inform the decision. But ultimately, the decision is looking at all of the situation, all of the context. Is this a marriage-like relationship? So that's not really helpful in my submission, because how do you actually know or advise clients this may or may not be a marriage-like situation? It's very difficult to offer any certainty. But as noted in Weber, and I have there, the indicators, while not a checklist, are helpful to reflect on and to help inform that contextual approach. And then one of the more recent decisions last year, Coden La Riviere, that was Court of Appeal decision last year, it stated no specific definition of whether a marriage-like relationship exists. The precise definitions of the past are no longer valid in our changing world. Such relationships are no longer defined by financial dependence, sexual relationships, or the mingling of property and finances. Now, traditionally, those factors, the financial dependence, sexual relationships, mingling of property and finances, were some of the key factors that courts would look at and say, oh yeah, you're sharing your bank account, you are having conjugal relations, and there's a financial dependency. That's a hallmark of a marriage-like relationship. Well, what the Court of Appeal in Coden La Riviere said, that is not, or no longer, the hallmarks of it. Now, is that a factor the court should consider in that contextual approach? Absolutely. But you, according to the Court of Appeal, you could have potentially a marriage-like relationship where there's no financial dependence, where there's no mingling of property and finances, and where there's no conjugal relations. That is a possibility. I think you'd have to have extremely good other contextual evidence to show that it was in fact a marriage-like relationship if you did not have those other factors. But it is still open to have that the court say that is potentially a marriage-like relationship. There was also the decision of Jones and Davidson, also decided last year by our Court of Appeal. And what that case, that one was dealing with the Estate Administration Act. All right. So the Estate Administration Act definition was slightly different than the Wills, Estate and Succession Act definition. So in my view, there's a limited usefulness to Jones and Davidson. I think the more important case for going forward would be Coden La Riviere. So I remember I said that there was no checklist and judges shouldn't do checklists. Well, what in fact the classic view, it was stated by an Ontario Supreme Court case back in 1980. And the hallmarks were set out in a checklist. And so the decision was, well, here are the factors that one would consider in determining whether something was a marriage-like relationship. The issue, however, was, all right, now I should say the issue is, you have to be careful when you're making submissions before the court. By all means, provide this list because these are all important factors to consider, but make it very clear to the judge, and hopefully the judge will then make it very clear in their reasons that this is not a checklist. They didn't mechanically go through and say, you know, if they meet all of these things or the majority of things, therefore they must be in a marriage-like relationship. That's not the analysis. You go through these factors and then you have to take a step back and say, in the context of this entire relationship, are these factors such that contextually and overall, they were in a marriage-like relationship? So the other thing I would comment, just before I quickly spin through these, is you have to be very, very careful. These were factors from 1980. That's almost 40 years or over 40 years ago. And so the factors that might have informed a decision in 1980 as to what a marriage-like relationship was, arguably, some of them still apply, but some of them may not current days. So you have to be very mindful of that and how some factors might have less importance then, or sorry, less importance now than they did then. So as I say, quickly spinning through them, shelter, did they live under the same roof, sleeping arrangements, what were the other people there? And by that, I don't mean children. That is, you know, were there other people who could potentially be spouses or in conjugal relations with them who were living there. Sexual and personal behavior. Again, conjugal relations. Court of Appeal has just said that's not a be-all and end-all. So you could have a platonic relationship that could still be considered a marriage-like relationship. I think the next one, do they maintain an attitude of fidelity to each other? Again, some of the commentary in the cases is, well, fidelity is important. Monogamy is important. But if both sides, and I stress that, if both sides are accepting of an open relationship, in other words, they're committed to each other, but they're allowed to, it's understood that they're allowed to have conjugal relations with other people, arguably they could still be in a marriage-like relationship. What were their feelings toward each other? I think that's a key one regardless. Did they communicate on a personal level? Did they eat their meals together, assist with problems during illness? Did they buy gifts, etc.? Services, in other words, how do things go on in the house? Again, I think these are all important comments about how the relationship worked. Social, I think the social and societal, in my view, is just as relevant now as it was in 1980. So you really do have to be very aware and do the due diligence to be able to determine or to be able to look into whether or not these were actually how they help themselves out to other people in the community. That is an important factor. Support, economic, what were the financial arrangements between the parties? And again, while the Court of Appeal has said that's not a mandatory aspect, I would suggest it is still a very important aspect. That are they viewing this as a communal living arrangement, that they are being with each other, as opposed to they're in silos and they're completely separated. Now, having said that, you could have relationships where even legally married couples have complete separation of their finances, and that's not an indicator of their relationship. So again, contextual. Children, same thing. I think that is important. Obviously, I think if you have children and you're not legally married, and how you treat those children and how you treat the other partner's child, I think would be important in terms of how it's represented, or whether or not they are in fact actually in a marriage-like relationship. And so what I would also say here is, in terms of marriage-like relationships, and just wrapping up, you have to look at the court determination of the subjective intention of the parties to enter into or remain in a marriage-like relationship. So again, I think a key aspect of this, overarching everything, how did the parties themselves view that relationship? And what was the way they presented themselves to the world? And what do they think of that relationship? If the evidence is that they viewed it as a marriage-like relationship, chances are it will be viewed as a marriage-like relationship. But as this quote suggests, just because you are in, or just because one party says, I'm not married to them, I'm not in a relationship with them, I have nothing to do with, I'm just sleeping with them. Well, that may be what they say, but the contextual factors may actually end up showing that, notwithstanding their individual protestations, it's not actually the case. That in fact, it is open to the court to find, notwithstanding those subjective intentions of that individual, it is not a marriage-like relationship. And I think the quote from Weber is particularly helpful in the sense that the intention here, particularly the expectation that the relationship will be of lengthy, indeterminate duration, I think is a key aspect of what the parties need. In other words, if they get together and they think it's going to be a long-term relationship and they live together for 2 years, chances are it will be a marriage-like relationship.